Hello, IP friends. Welcome to IP series with your favorite podcast host, Rita Amuri Chinda. I'm sure you guys have had a blast so far. For my new listeners, thank you for listening to my podcast. Basically, I talk about intellectual property in form of copyright, trademark, patent, industrial design, trade secret, geographical indication, and plant variety. So if you have stories you want me to talk about or give my views about, to share comments, just send me an email to ipseriesinfo@gmail.com. You can also send me a DM to ipseries_with Reader is spelled REEDAH on Instagram, or just send me a DM on Twitter at ipseries1. For my returning listeners, you guys are the best. Thank you guys for always coming back to listen to me talk about what I left to talk about. Okay, let's get into this conversation. I don't know how many of us have come across the Ikorodu Boys or any other well-known film fan maker out there that likes to do like their own version of a trailer or music video or a particular scene in a movie. So this story is for filmmakers, it's also for fans who are inspired by the creativity that these actors and scriptwriters and producers and directors have come together to do. But if you're also in the animation industry, then this is also a good episode for you to learn about intellectual property. If you're a SpongeBob fan, oh my gosh, I'm sure you guys came across this story because I got tagged on this story in a WhatsApp group by a colleague. Her name is Millicent Umoru. Hi Millicent. If you get to listen to this episode, thank you for drawing my attention to this story. But yeah, Millicent posted the link to the story, and I was like, I need to get your views about this, and I was like, sure thing. So I went on Twitter and I checked out the hashtag Justice for SpongeBob, and I was like, ooh, sounds interesting. But basically, it kind of introduced me into a world that I never really took. How would I say this now? Like, I didn't really pay so much attention because I didn't really think there was like IP implications. But this case basically blew my mind. So, Justice for SpongeBob is basically how copyright affects the film and animation industry, and what filmmakers or film fan makers should know when dealing with intellectual properties. So I'll just get right into our story. I'll get into our story for today. Oh yeah, story. So a couple of weeks ago, a Twitter user by the handle at PencilWorkshop, who happens to be an animator, a YouTuber, is also an artist, went into a collaboration with other animators like himself. They embarked on a 2-year project recreating the famous SpongeBob movie. So they titled this SpongeBob Rehydrated, SpongeBob SquarePants Rehydrated. And the main reason for doing that was to pay homage to late Steven Hillenburg, who happens to be a famous American animator. He is a writer, a producer, director, and also a marine science educator. How inspiring, guys. And also the creator of SpongeBob SquarePants, which was or still is a mega hit cartoon series on Nickelodeon, which was first aired on the 1st of May 1999. If you were still a kid then, I'm sure this cartoon series kind of resonated with you. And so far it has 250 episodes. My podcast is just 70 episodes shy. I think 2 or 3 to make it into the 70th episode, guys, and someone already has 250 episodes. But let me not digress. So he said that he was inspired based on his interest and love for the sea and his creature and the creatures in the sea, basically. And the cartoon series was later developed or adapted into a movie in 2004. So that's like 5 years later, with a sequel titled SpongeBob Sponge Out of the Water in 2015, which Steven also wrote, produced, and directed. Now, PencilWorkshop and his co-collaborators decided to pay homage and create this remake, or I don't know, just create another SpongeBob SquarePants rehydrated movie. They went ahead to upload the animation on YouTube, and Paramount Pictures, who happened to be a distributor, had to, trigger the copyright takedown notice via a copyright violation, which is available on YouTube. And that was how the justice for SpongeBob became viral and was banned. I mean, I think when I first came across that tweet, I saw over 18,000 likes, and I was like, ooh. And it just kept growing and growing and growing. So his tweets reads as follows. So I'm just going to read it out for you guys. It says, we all worked, Justice for SpongeBob, we all worked on this project for 2 years and poured in an original animation, art, voice, acting, music, and everything. We volunteered for this project and made zero money off it. We did it all to dedicate this to Steven Hillenburg and the show he made. By original, I mean we did everything by ourselves. We had our own voice actors playing the characters. None of the original voice acting from the movie was used to make this. Even our music score was done on our own composers. This was all fan made, and we made zero money on this. So if you've seen I think they put it back on YouTube, so you guys can check it out and compare and also have your own views. So he went ahead to say, justice for SpongeBob. We worked too hard on this for this to be ignored, not denied. All 400 plus of us animators, voice actors, artists, composers, organizers, and more, we made this as fans because of our love for the show and to honor Steven Hillenburg for inspiring all of us. I'm so touched, guys. Oh, but there are no emotions when dealing with intellectual property. I mean, it's all about facts and evidence and documentaries. But it's kind of exciting. I love to watch behind the scenes. Because I appreciate the work put in a creative content out there. So everyone who has, so this is like 400 plus contributors. Everyone has contributed one thing or the other. But let's look at it from my own point as an intellectual property practitioner. So I did normally I like to ask questions, put up a poll in all of my mini series on Twitter, just to get a feel of what people actually think about the case before I also give my own view. Now, the question is, did the fans have the right to recreate this version of SpongeBob SquarePants? 21% said yes, which I'm surprised. 21% said yes, while 79% said no. And I went further to ask, do they also require the consent of the estate of Steven Hillenburg and the distributor Paramount Pictures? 94% said yes. 6% said no. I mean, if you answered yes, that they needed the consent of the estate and also the distributor, why then would you say that the the fans have the right to recreate their version of SpongeBob, because when you're dealing with intellectual property, consent, permission, authorization, CPA, basically it's very important. Without that, you're committing an infringement. You're infringing on someone's right. You are using the work illegally, unauthorized. So, because they are not the original owners of the movies, they will also be required to get CPA from the right holders who have copyright in the work. The US, so this is basically a United States case. So I'll give the Nigerian perspective and also talk about the American perspective. So the US copyright law also protects literary, musical, artistic works such as poetry, novels, movies, computer software, pantomime, graphics, audiovisual works, etc. One thing you should know is that copyright protection has nothing to do with making a profit, but acting on your intellectual property right, which includes the right to reproduce the work in copies, prepare derivative works, perform and display the work in public, distribute copies to the public by sale, lease, or rent. So, PencilWorkshop and his team can't exercise any of the above right because they do not have the original copyright to SpongeBob SquarePants. Let's not even talk about the sequels and all the other ones. SpongeBob SquarePants belongs to the distributors and the estate of Steven Hillenburg. A copyright owner has the economic right to earn either by licensing or commercializing it in any other way they deem fit, by going to partnerships, collaboration, building a merch brand, commercializing a character, you name it. They can make money from their work. They can even sell it. They also have the moral right to prevent any modification of the work. Now, based on this new creation, can the team of fans be co-owner? Yes, they can. I mean, they are like 400 plus. So, and each of them had a role to play in the making of the SpongeBob SquarePants rehydrated movie. Now, section 11, sub 6. Apologies, guys. I'm a lawyer, so deal with it. Paragraph A of the Nigerian Copyright Act states that you can share joint interest in the whole or any part of the work, and which also applies to the US copyright law, which provides that they can enjoy equal rights to register and enforce the copyright. So the 400 plus members that created this movie can enjoy equal rights and enforce their copyright. But then a contract with states what percentages are accrued to everyone that has contributed based on their roles. Now, before PencilWorkshop and his team embarked on the 2-year journey to recreate the movie, they should have gotten the consent, an authorization of Paramount Pictures and Viacom, who would then authorize them to reproduce the movie. I mean, they keep hammering on the fact that the goal was not to make money. I mean, like I earlier stated, copyright does not really care about profit making. It's all about you acting on your intellectual property rights. Because, I mean, you are the original owner, you are the author, you are the owner. So why would someone keep making emphasis on, oh, I used your work but not for money? I mean, fair dealing has this, defenses, or fair use as the case may be. But let's move on, guys. So, considering the nature of the work that went into the making of SpongeBob SquarePants rehydrated movie, and the defense that it wasn't for commercial purpose, I mean, it would have made sense if consent was gotten. But when you decide to plead defense of non-commercial purpose, which is called fair use in the US and fair dealing in Nigeria, I mean, you should be doing it for research purpose. And basically, this was not for research purpose. This was it wasn't even for private use. Now, fair use in the US is said to be like a legal doctrine that promotes freedom of expression, by permitting the unlicensed use of a copyrighted work in certain circumstances. Now, according to the United States Copyright Office Fair Use Index, its objective is to make the principles and application of fair use more accessible and understandable to the public by presenting a searchable database of court opinions. You guys, please check it out. Which includes categories and type of use such as music, internet or digitization, parody. Then section 107 of the U.S. Copyright Act talks about limitations on exclusive rights used to evaluate a defense of fair use, to include purpose and character of the use by the team or fans, including whether the use is of a commercial nature or is for non-profit educational purposes. Then the nature of the copyright in question, which in this case would be the SpongeBob SquarePants movie, the effect of the use in the market and the value of the copyright work, and finally the amount and substantiality of the portion used in relation to the work. Remember, they had said that they did a remake, but everything from the voice to the song to the score to the actors were original. You get? So if you put it side by side, how much was used? Is it everything? Can you say it's whole or part? How are you going to evaluate that? So this 4 things that I listed is known as the 4-factor test used to evaluate if the use of a work meets the fair use principle, and has been used. This has been used in a number of cases, particularly in the US. Now, types of fair use I had alluded to include private use, teaching, news reporting, criticism, comments. So I took a poll, like, can PencilWorkshop and his team, that's 400 plus people, still use the fair use defense? And 29% said yes, 57% said no. I will agree with you guys. They can't be relying on fair use in this instance. I mean, the purpose and character of the use, so whether it's for commercial purpose or not, they are towing to the line of, oh, it's not for commercial purpose. But we all know, when you put that content on YouTube, you're doing that other than, educating people or building your brand. You're basically going to make money off YouTube. So they haven't come out to say any money generated from that to be donated to the estate or for a project or blah blah blah, whatever. They haven't done that. 14% said maybe. Why maybe, guys? Seriously. Anyways, creatives need to understand some basic things when dealing with intellectual property. 1. Intellectual property grants exclusive right to the IP owners to exploit and commercialize their creativity. 2. In order for a third party to use a whole or substantial part of the already created work expressed in a fixed or tangible format, consent, permission, authorization is needed. As failure to obtain it, your actions will be deemed to be an infringement on the intellectual property owner's exclusive rights. So for instance, now, PencilWorkshop and his team had the movie taken down for copyright violation. Now, does the fact that it was recreated with no intention to make profit or money really matters? 20% said yes. 80% said no. What are my thoughts? Okay. The answer is yes, because intellectual property has nothing to do with profit making, even though you have economy right to generate money. But your goal, first of all, you're making a work not with the sole intention of making money, you get, but because you want to have control and get the support of the law in your territory, so that when you do decide to exploit it, you are legally and fully protected in that jurisdiction. So for instance, now in the US, you cannot assume that your work enjoys automatic protection like in Nigeria, because you are required to register your work with the Copyright Office before you can actually sue for copyright infringement. And this was as a result of the Gigi Hadid case against a famous paparazzi photographer. So the court had said, if you're going to actually sue for copyright infringement, I need to see evidence that you have registered your copyright. So yeah, that's about that. So let's move on to the most important conversation. The most important conversation for this episode. Now remember that Pencil Workshop and his team are fans who were inspired by Steven Hillenburg's movie and decided to do their own version and called it SpongeBob SquarePants Rehydrated. So I did another poll and I asked, have you ever heard of fan film? And 29% said yes, 43% said no, 29% said tell me more. So I'm going to tell you more about fan film. Fan film is like a passion project for movie lovers. It's like a labor of love to create something that you understand. It's not going to give you returns, tangible return. Pencil Workshop and his team work are based on someone else's creativity. In this instance, Steven Hillenburg and Paramount Pictures and Viacom. So what is then the relationship between fan films and intellectual property? First off is copyright, because films are considered to be eligible work as a type of IP mechanism, such as, SpongeBob SquarePants. It also involves creativity of the mind. The thin line as to the exclusive rights in the recreated movie and the original myth. So there's a thin line basically between the exclusive rights in the recreated movie. So what exclusive rights do Workshop? What exclusive right do Pencil Workshop and his team have? And what exclusive right do the original movie maker have? Excuse me. Now, a fan film has guidelines which must be adhered to. For instance, CBS and Paramount Picture have one for anyone who wishes to reproduce as a non-professional and amateur for Star Trek. I don't know how many of us are Star Trek fans, but if you've ever wanted to recreate a Star Trek movie, you will need to follow CBS and Paramount Pictures fan film guidelines. One, they said fan production must be less than 15 minutes for a single self-contained story, or no more than 2 segments, episode or parts, not to exceed 30 minutes total, with no additional seasons, episode, parts, sequels or remake. This SpongeBob Square guys, apologies. This SpongeBob SquarePants movies is about an hour or more long. So basically it doesn't really fall, if you're going by the guidelines of Paramount, because Paramount Pictures is one of the owners of the movie. So if you're going by their guidelines, so each filmmaker or movie brand has guideline depending on the movie. So the guideline I'm reading for you now is the fan film guideline for Star Trek fans. And then you must not be a professional, you must be an amateur. So you could be using your phone or a low grade camera to record and edit and all the rest of them. The title of the fan production or any part cannot include the name Star Trek, which is the mistake that Pencil Workshop and his team did. They included the production and named it SpongeBob SquarePants. That's where the issue came about, but I don't think they're seeing it from that angle. So they went further to say, however, the title must contain a subtitle with the phrase a Star Trek fan production, which this isn't what Pencil Workshop did. He didn't say a SpongeBob SquarePants fan production. Do you guys get? So let me just look for the link on YouTube and see how it's, or let me just, you guys can just check it out on YouTube basically. And they say it has to be in plain typeface. The fan production cannot use the term official in its title or subtitle or any marketing, promotion or social media for the fan production. the content in the fan production must be original. Now, what Pencil Workshop and his team considered to be original to them were the actors, voice actors, the score, music score, the animators, etc. Which doesn't really fall, if you're going by the guidelines of CBS and Paramount Picture for fan films, it doesn't really, fall within that. Next up, I will be talking about what to look out for. Why? What's the reason for you to pull down copyrighted videos? So sometimes you get your video, even on Instagram, Facebook, you get your videos pulled down or your content pulled down for copyright infringement. So let's look at the guideline for YouTube. Look, the reason why YouTube pulled down the video. Every social media platform has the terms of use, which has rules for its users. There's also a provision for intellectual property where you have to certify that you are the owner of the work and it does not belong to a third party. So I'll read YouTube's terms of use. So the clause is your content and conduct, uploading content. If you have a YouTube channel, you may be able to upload content to the service. You may use your content to promote your business or artistic enterprise. If you choose to upload content, you must not submit to the service any content that does not comply with this agreement or the law. For example, the content you submit must not include third-party intellectual property such as copyrighted materials unless you have permission from that party or are otherwise legally entitled to do so. You are legally responsible for the content you submit to the service. You may use automated systems that analyze your content to help detect infringement and abuse such as spam, malware, and illegal content. Now, you can Google terms of service of YouTube. It has welcome to YouTube, who may use the service, your use of the service, your content and conduct, account suspension and termination, which basically explains how you and YouTube may terminate this relationship, about the software, other legal terms, about the disagreement. So just check it out. Before you, and a lot of people complain that terms of use or terms and conditions are always very lengthy, but it would help if you can actually read the terms of use. So even if you're signing up to another platform, what are the terms of use, what are the terms and conditions? If you own a website or an app and you don't have a terms of use or terms and conditions or privacy policy or cookie policy, please reach out to your data protection lawyer or information technology lawyer to help you, or your privacy lawyer to actually help you draft a proper terms of use, a proper privacy policy, a proper cookie policy, just so you protect yourself from anything, especially because now we are in the digital era. It's easy for someone to just rope you into a dispute that you're not supposed to be involved in the first place. So you need to be proactive before you're involved in some kind of messy things. So if you recall, sometime in 2019, popular Nigerian female artist Tiwa Savage, if you've heard her latest song, somebody song, let me stop there. Well, you've somebody's song. I'm sure you've heard of it. You've done TikTok versions and the rest of it. Her song in 2019 titled "One" was taken down from YouTube 48 hours after her co-musician called Danny Young went on his Instagram page and called her out for taking a line out of his 2009 single Oju Ti Won. I beg, if you're Yoruba, pardon me. Apologies. Oju Ti Won. Yeah. So Danny Young accused Tiwa Savage of taking a line out of his 2009 single, Oju Ti Won. And that video was taken down 48 hours later. So I did a poll again. Do you remember? 50% said yes, 30% said no, 30% asked me relevant. Are you guys joking? Okay, so I'm going to tell you why it's relevant. Now, the notice, takedown notice, is included in sections of the Digital Millennium Copyright Act, which regulates how copyright owners and internet companies would share responsibility in dealing with online copyright infringement. So, yeah, you have to take it seriously. Now, in the event that you get a takedown notice from YouTube, you know that you are required to put in a counter notification, and if your act was in good faith meaning that you didn't mean ill, it was for fair use, then you have the legal right to the material, which the case for the team of fans, that's PencilWorkshop and his 400 plus team, would have to obtain license to use SpongeBob SquarePants or invoke the fair use defense. Now, I did another poll again, and it does not really have much votes, just 3 persons voted, so I don't think it is good enough. But I asked, would the team of SpongeBob SquarePants fans pass as a transformative or derivative work? 67% said derivative, 33% said don't know. So I'm just going to explain the difference between a derivative work and a transformative work. Now, a derivative work represents a new version of a copyright material that is based on a pre-existing work, for instance, an adaptation from a book to a movie, which to my mind is not the case. But in the case of Steven Hellenbach adapting the cartoon series into a movie, that's a derivative work. And does SpongeBob SquarePants rehydrated movie qualify as a derivative work? 100% said yes, and 0% said no. Well, my answer too was yes, because the fan film SpongeBob SquarePants rehydrated movie meets the requirements of a derivative work, especially since it used a substantial amount of pre-existing work and still obtained a written license and authorization from Paramount Pictures. Although when this had, I think the day it was released, I think it was early May this happened, there was a disclaimer from Viacom which says the following feature is a recreation of an existing film produced by Viacom, who holds all rights to this intellectual property right. We do not claim ownership of the said right, and this project is treated for non-profit. No person involved had made any money of the content. This recreation was made with the help of several hundred artists from around the world as a tribute to the late Steven Hillenburg. Everything, including both visuals and sound, was originally created for this feature and falls under parody law. And so yeah, I hope that makes sense. I was going to say the poster looks really nice, and you can check my post about it. So yeah, take note that Paramount Picture as a copyright owner of the SpongeBob SquarePants still has right to the derivative work of the SpongeBob SquarePants rehydrated movie. Section 101 of the US Copyright Act provides that a transformative work adds something new with a different character than the underlying work. I don't think the SpongeBob SquarePants rehydrated movie was a transformative work here. So I don't know if you guys agree with me, but if you do not, please let me know in the comment section, guys. Let me know in the comment section, or just send me a voice note and I will respond. So we are wrapping up our conversation so far. I hope you guys have been following my story. But yeah, so in summary, you need a written authorization from an IP owner to use an intellectual property. Justice for SpongeBob is trending because of copyright violation. You need to also be guided as to how copyright affects your industry. Most film production companies or movie franchises have a guideline for fan films, e.g. Star Wars or Star Trek. Please check them out before you want to do a remake or whatever. The fair use principle applies when you use a work for reporting news. As an intellectual property owner, you have the moral right to prevent third parties from distorting the work and hurting your image and reputation. So, do you think that Paramount Pictures exercise their moral right, trying to prevent PencilWorkshop and his team from distorting or modifying the SpongeBob SquarePants movie franchise? Let me know as well. IP has nothing to do with profit making, but giving intellectual property owners legal backing and protection in a particular territory. Copyright grants the owner automatic protection from the moment the work is made. So, as an animator, here are a couple of things you need to know. Again, I'm just going to talk about it like brief summary. Animation is a combination of both creativity and innovation. Your animation could enjoy copyright and trademark protection. Copyright in for animation would include the expressions, from the pictures to the images to the song. So far as it's in a fixed medium, you also have the right to reproduce or make adaptation. You can also make it into a cinematograph film or record it or distribute it. The owner of an animated work, who owns it? It's basically, generally, the creator owns the work from the moment it was made. Unlike other IP where it is important that you register it. Circumstances where the work may not be owned by you could be when it's done in the course of an employment, if you were hired, or if it's a joint work. Time of duration for copyright, very important, guys, is for the lifetime. So for as long as Steven Hillenburg was alive, plus 70 years after the end, in which once the 70 years expires, it goes into public domain and anyone can use it. For instance, now the Mickey Mouse copyright is going to elapse in 2 years' time, as in 2024, and mischief, as always, is being mischief, has already created like a merch, a mini merch or a limited merch, preparing for Mickey Mouse going into the public domain. But yeah, let's see how that works. So can an animator explore a multi-layered IP protection for its animated work? The answer is yes, because any type of IP another type of IP that an animator can explore is copyright. So remember I talked about copyright and trademark rather. Trademark protects the name of the movie, like SpongeBob SquarePants, the logo, the design, the characters of an animated work. Now, the role of IP in animated work would include having the creators explore merchandising of animated characters, licensing the work to generate funds. Filmmakers and businesses can have what is known to be, you can explore product placement, where in the movie you see brands work or products are being placed in certain image, or a particular character is using it. Product placement basically is when a branded product is used in the storyline of a movie. This helps save costs. It's also a means for advertising and reaching consumers from the brand's perspective. Now, the value of IP comes from having a good IP strategy that records exclusivity. Then another thing is that intellectual property rights can increase the financial return from you investing. You can turn intangible assets into exclusive property rights, which is then exploited. And yeah, animators, authorities, we need support of the public so that we will have a thriving animation industry in Nigeria, because the animation industry globally is huge. It's really huge. Like, I don't know, guys, but you guys need to start. We need to start taking all of these things more seriously here in Nigeria. We need to also know the basics. So I hope that with this commentary, my commentary on the Justice for SpongeBob case, filmmakers, fan filmmakers, brands, and everyone involved in the film industry, even as a consumer, you start taking notes of all of this. That the fact that you so you have to be careful how you share content, so you're not accused of infringement. If you're doing a remake like the Ikorodu Boys, What are the things you need to look out for? If you're an animator, while creating animations, make sure that you're using original content. If you're inspired by someone, you also have to talk. At least acknowledge them. So we've come to the end of today's IP series episode. Yeah. So we've come to the end of today's IP series. We've come to the end of today's IP series episode. So I just want to say thank you to all my IP friends for listening, for sharing, for liking, for favoriting. I mean, I see all the notifications. Thank you guys so much. So if you are an animator, or you know an animator, a filmmaker, or you are a fan of a movie, I mean, right now Stranger Things is doing the numbers, guys. I mean, I watch a couple of behind the scene, I'm like, oh, I need to get into this. So as a fan or a lover of a movie or series like Game of Thrones, Star Trek, Bridgerton, Stranger Things, yeah. I think I'm being naughty right now, but let me just say thank you guys. Thank you so much. So filmmakers know the basic when it comes to intellectual property. Fans, please learn about intellectual property. If you're interested in a curated IP related training, send me an email to ipseriesinfo@gmail.com or a DM to ipseries_with_reader or at ipseries1. Yeah. So thank you once again for listening to me ramble and talk about what I love to talk about. But yeah, thank you guys, and thank you Millicent for this case. So round of applause guys for Millicent, and have a fantastic day guys. Bye bye. So we are wrapping up our conversation so far. I hope you guys have been following my story. But yeah, so in summary, you need a written authorization from an IP owner to use an intellectual property. Justice for SpongeBob is trending because of copyright violation. You need to also be guided as to how copyright affects your industry. Most film production companies or movie franchises have a guideline for fan films, e.g. Star Wars or Star Trek. Please check them out before you want to do a remake, whatever. The fair use principle applies when you use a work for reporting news. As an intellectual property owner, you have the moral right to prevent third parties from distorting the work and hurting your image and reputation. So, do you think that Paramount Pictures exercise their moral right trying to prevent PencilWorkshop and his team from distorting or modifying the SpongeBob SquarePants movie franchise? Let me know as well. IP has nothing to do with profit making, but giving intellectual property owners legal backing and protection in a particular territory. Copyright grants the owner automatic protection from the moment the work is made. So, as an animator, here are a couple of things you need to know. Again, I'm just going to talk about it like brief summary. Animation is a combination of both creativity and innovation. Your animation could enjoy copyright and trademark protection. Copyright in for animation would include the expressions from the pictures to the images to the song. So far as it's in a fixed medium, you also have the right to reproduce or make adaptation. You can also make it into a cinematograph film or record it or distribute it. The owner of an animated work, who owns it? It's basically, generally, the creator owns the work from the moment it was made. Unlike other IP where it is important that you register it. Circumstances where the work may not be owned by you could be when it's done in the course of an employment, if you were hired, or if it's a joint work. Time of duration for copyright, very important guys, is for the lifetime. So for as long as Steven Hillenburg was alive, clause 70 years after the end, in which once the 70 years expires, it goes into public domain and anyone can use it. For instance, now the Mickey Mouse copyright is going to elapse in 2 years time, as in 2024, and mischief, as always, is being mischief, has already created like a mini merch or a limited merch, preparing for Mickey Mouse going into the public domain. But yeah, let's see how that works. So can an animator explore a multi-layered IP protection for its animated work? The answer is yes, because any type of IP another type of IP that an animator can explore is copyright. So remember I talked about copyright and trademark rather. Trademark protects the name of the movie, like SpongeBob SquarePants, the logo, the design, the characters of an animated work. Now the role of IP in animated work would include having the creators explore merchandising of animated characters, licensing the work to generate funds. Filmmakers and businesses can have what is known to be you can explore product placement, where in the movie you see brands work or products are being placed in certain image, or a particular character is using it. Product placement basically is when a branded product is used in the storyline of a movie. This helps save costs. It's also a means for advertising and reaching consumers from the brand's perspective. Now, the value of IP comes from having a good IP strategy that records exclusivity. Then another thing is that intellectual property rights can increase the financial return from you investing. You can turn intangible assets into exclusive property rights, which is then exploited. And yeah, animators, authorities, we need support of the public so that we'll have a thriving animation industry in Nigeria, because the animation industry globally is huge. It's really huge. Like, I don't know, guys, but you guys need to start. We need to start taking all of these things more seriously here in Nigeria. We need to also know the basics. So I hope that with this commentary, my commentary on the Justice for SpongeBob case, filmmakers, fan filmmakers, brands, and everyone involved in the film industry, even as a consumer, you start taking notes of all of this. That the fact that you so you have to be careful how you share content, so you're not accused of infringement. If you're doing a remake like the Ikorodu Boys, what are the things you need to look out for? If you're an animator, while creating animations, make sure that you're using original content. If you're inspired by someone, you also have to talk, at least acknowledge them.